Did you know that to end slavery in the United States, Abraham Lincoln had to take on the Supreme Court? When he issued the Emancipation Proclamation, Lincoln went against the Supreme Court's Dred Scott decision, which said that the federal government didn't have the authority to free slaves. So it turns out that the Supreme Court doesn't have the final say on laws in the US, at least when elected leaders find the political will to challenge its rulings. And like other branches of government, the judiciary is subject to checks and balances. So with the public's confidence in the Supreme Court dropping to all-time lows, let's look at 5 ways the institution can be checked, and ask, does it even need to exist? There are currently 9 Supreme Court justices, but you might be surprised to hear that this number isn't in the Constitution. In fact, the number of justices on the court has actually fluctuated throughout the history of the United States. Today, Congress could easily increase the number of justices on the court to outnumber the court's unpopular conservative majority. This actually happened a lot during and after the Civil War to bring the court in line with Reconstruction and ending slavery. A few decades later, President Franklin D. Roosevelt tried to do the same thing after the Supreme Court struck down popular New Deal programs. At the time, polls showed that most Americans thought the court should be more liberal on New Deal cases. In one of his fireside chats, FDR accused the court of using its power to veto progressive laws.
The court has been acting not as a judicial body, but as a policy-making body.
In the end, FDR didn't get Congress to add more seats to the court, but his threat seemed to work. The court began ruling more in favor of the New Deal, and at least part of the reason was to get FDR and the public off its back. If court packing seems like a tough sell in the current moment, and it might be considering that even FDR couldn't pull it off, another more popular fix could be term limits. 2/3 of Americans across the political spectrum would support such a move. See, right now, justices can serve for life, but term limits would put that to an end, and kick justices off the court after a certain number of years. That would likely make it easier to ensure that the Supreme Court reflects the current political climate. The only thing is, it's unclear if Congress can impose term limits on justices who already sit on the court, and the constitutionality of that law would have to be decided by, you guessed it, the current court. And they might not give up power that willingly. But that brings up the next point. The first 2 solutions we looked at solve the problem of who sits on the court. But Congress can also control what cases the court rules on. Congress can write laws that take away the court's ability to rule on particular issues or particular types of cases. This is called jurisdiction stripping. For example, some progressives in Congress want to strip the court of its authority over abortion cases. Even the Constitution itself states that the Supreme Court isn't so supreme after all. Article 3, Section 2 states, "The Supreme Court shall have appellate jurisdiction under such regulations as the Congress shall make." That means Congress can place regulations on the unelected court's power. But something else seems to be getting lost in the court's approach to law. Like FDR said earlier, it's not the judicial branch's job to set policy and make laws. Congress is the legislative branch. They're the branch that makes the law. So Congress can actually pass laws to counter Supreme Court rulings. For example, in the late 80s, the Supreme Court weakened the Civil Rights Act of 1964, saying the act didn't protect against discrimination in the workplace. In response, Congress passed the Civil Rights Act of 1991 to explicitly add those protections. Today, Congress can do the same by codifying Roe v. Wade. If it happens, the right to an abortion would be made into an explicit law, which has never existed at the federal level. Then abortion rights would be more protected from the Supreme Court's interpretations. Congress used to do this way more often before perpetual gridlock was the norm. But even if Congress fails to act, the other elected branch of government, the executive branch, has a last-ditch option to check the court. Now, this might seem like the craziest move of all, but if push came to shove, the president could straight up ignore Supreme Court rulings. And that's particularly important when those rulings are unpopular or immoral. For example, like we mentioned at the start of this video, Lincoln openly defied the Supreme Court. In fact, while running for president, Lincoln campaigned against the Supreme Court's interpretation of the Constitution itself. At his first inauguration, Lincoln even said that if the Supreme Court had final say on government policy, quote, the people will have ceased to be their own rulers. Lincoln regularly used his office to check the court. His administration did things like, in one case, issue a passport to a free black man, even though the court's Dred Scott ruling had declared that black Americans were not US citizens. Each time Lincoln made one of these moves, he justified it with his own interpretation of the Constitution, saying that the Supreme Court's interpretation was wrong and not the final word. So today, the elected branches of government, the executive and legislative, have all these options at their disposal to rein in the court. But it's important to ask yourself why a bunch of unelected judges have so much political power in the first place, and why the system has kept it that way for so long.